It's 2 days time.
Item 9.
Well, item 9, where the exemption exempt in the TET qualification.
Now the judgment has come.
Yes, my lord.
Justice Datto's judgment has come.
That is annexure. My lord. That I have highlighted
On that basis, yes.
that is available.
Justice Datto has recently said that the NCRT has closing off in the light of this sense.
My lord, your lordship kindly have glanced to your lordship into occasion of one of the cases where the reverse prayer was made. Your lordship was going to dismiss, and after going through this adjournment judgment, and on the request of the government, my lord, your lordship formulated the point also. Your lordship kindly.
So formulated the point, we are deciding it here. Then what formulated the point?
My lord, yes, we have.
Why you are referring it to it?
Well, I am referring to reason being, since this batch of cases, the exemption.
First, let it be decided, then everybody will follow with the same. Next. Let this matter be decided on the basis of this judgment. What remained? Can we argue anything beyond that?
No, madam.
Then
But
what remained?
my humble submission is the provisions as available under elementary cadre rule exempting the qualification that should be declared ultra virus. That is my prayer A, madam. And B is be given promotion to the all qualified person having TET qualification. We are all pensioners having TET qualification. In the first case, your lordship. And I have prayed for my prayer may kindly have granted.
Because my lord,
Let me complete my last one and this is for your lordship. Kindly turn to prayer matter. What is my specific prayer?
the view is pending before the Honorable Supreme Court. That order which is relying upon that has been reviewed by.
No, this is another matter.
Yes, it was not. Condition, subject to your lordship's acceptance.
No, we didn't know. But he has gone much ahead. We just thought that the order has been passed by the government denying them certain rights because they do not have the TET qualifications. So we thought that after this judgment it is imperative. So giving them a time to qualify this, there is no difficulty. We were thinking, but now he says that the provision has to be declared coronavirus.
Yes. We are all qualified teachers. Our promotion has been blocked, my lord, by the underqualified teachers.
They have been promoted.
And they have been promoted. That's why we have challenged the virus of this 15-2D malady.
So now, suppose the virus is declared, will it take a retrospective effect? Prospective.
That the constitutional-based judgment, madam.
That will take a respective. All action which has been taken at that point of time will go.
My humble submission.
I have to learn. You show me that you say constitution based. I have to understand because I am ignorant. I am ignorant. I must be very candid. I am ignorant.
It is available.
I am ignorant of this proposition of law. So that's why I am asking.
I have, my lord's predecessor, all the judgments were placed. In the last judgment, your lordship kind of
Please.
That point I also taken care of.
Because there is another facets of the legal, I would say, the field. So that is whether those principles of the doctrine can apply.
What I say, my lord, here, certainly, my lord, so far the TET qualification is concerned.
It is imperative now, as of this day, after this judgment says it is imperative.
Yes.
It is mandatory. I'm sorry, I use wrong words. I will use those words which all of you use.
All of us.
Yes. So
that has been invoked by
so it is mandatory now. There who has not who has not done it, a timeline has been given within which they have to complete it. Please consider, even if they have been given a promotion, if the Supreme Court has given them a fresh lease of life for a limited period, if they qualify the TET examination, then will you say that their promotion was bad at that relevant point of time?
I am just coming to the point. That is the crux, man. That is the crux, man. You require to. I am coming to. Your Lordship kindly.
The credit must go to me.
I understand, Bharat. Your Lordship formulated the point. Here, in the Anjuman case,
wayward. You were going wayward.
No, Bharat, I am not going to that. My humble submission with Your Lordship kindly appreciate
his energy level.
Your Lordship, because it is giving much more pain, Bharat. We have concluded hearing, it could not be, the judgment could not be delivered. In from 2023, still it is not being ended. And the unqualified persons, they are getting promotion one by one. And you will not see kindly appreciate.
Saying to this stage, he had the, I think, the first or the second offender. Consider.
That's
bringing both those facts.
why I am drawing
To argue. Tell me what to do.
In the Anjuman case, those who have got promotions, they have to qualify and they will retain the post. That was not the issue, man. Your Lordship will kindly appreciate various the SLPs was clubbed together, even against the judgment of the Madras High Court, where the rules were declared for ultra-virus. That against that judgment, SLP was filed. But my humble submission here, everything has been discussed elaborately. Nothing more I have to say in paragraph. But my humble submission, there they say, for promotion, certainly TET is mandatory. Nobody is to be has any right to consider for promotion without TET. Therefore, they say, even teachers, those who have only 5 years of service or less service, they may continue without promotion till their retirement. But those who have more than 5 years of service, by invoking Article 142, they will continue if they will acquire the TET qualification by 2 years. Otherwise, they will be given compulsory retirement with all terminal benefit if permissible under the rules manner. My humble submission before Lordship is, here what has happened? The provision which we have challenged that came in the year 2019. Promotions on the basis of that exemption were made in 2001, 2021, 22, 23. Your Lordship kindly appreciate, if at all this, while we are available and they have been given promotion, unless and until this provision is declared ultra-virus, then certainly they will march over and they have blocked our promotions. Entire promotion post they have awkward manner.
I'm again asking a question. Let us hypothetically, don't take it as my observation or become more energized or enticed with that. It's only for the purpose of understanding or putting a question. Let us proceed on a hypothetical basis that whatever you are saying is correct. Let us proceed that we declare the particular provision of the statute to be ultra-virus. Then the larger question, any action which has been taken prior to the declaration of the provision to be ultra-virus, what would happen to those actions? Can they go in air? Can they be buried 2 meters beneath the ground? What? We are concerned with this situation now. You are saying everything. Now let us see that we proceed on that basis. What relief can be granted to you? Tell me. What would happen to those?
My humble submission before Lordship, even in 2003, where the matter was for the first time issued notice, in case, my lord, that order is there, any promotion subject to result. If your Lordship, my lord, in the event, the provision...
Sir, this provision, according to you, came in existence in 2019. The promotions have been done in 2019, 20, 21, 22.
Malad.
I am saying that when there was the provision enacted by the legislators using their legislative power, if the authorities or any action is taken thereupon, what would happen to that action?
Malad, let me.
Today, we declare this provision to be ultra violence.
Yes, Malad, that is Malad. But I am just coming to Malad. I understood the proposition, Malad.
Don't go 2003, 2005 model.
Malad. Oh, right.
Forget about it.
Malad, my humble Malad.
When the exemption clause is brought to the statute book in 2019 and the action taken thereafter.
Sure. So, Malad, I am just coming to that is the crux, Malad. That I have, Malad, I know that is the issue is required to be answered. Malad. Here, your Lordship will find the exemption provision which came by way of amendment that is not under the subordinate legislation. That is by invoking provision to Article 309. But by that time, the 17th Amendment of RCFC Act has already came into force, being incorporated to the RCFC Act, RTI, in the year 2017 by giving effect to, with effect from 2015, with 4 years grace period. Earlier, under the statute, under Section 23, 5 years was the relaxation period. 4 years by way of amendment in 2017 came into force, which period is to be ended by 31st March 2019. This Gazette notification, in exercise of power of 309 proviso, came into force because in Odisha, the elementary cadre rules which was governing previously prior to commencement of this RCFC Act, but that got amendment in 3 stages in 2009, 2014, 2019. We are concerned with 19, confining to our issue with exempting the qualification which was prescribed under RT Act, redoing the NCT notification, as it has been declared in only one case. My humble submission before Lordship is, had it been in legislation, your Lordship, my Lord, I bow down, then yes, certainly that question would have arrived. Here is the provision which we have asserted solely on the ground that it is hit by the doctrine of occupied field. That means the governor power to issue the amendment or bring such provision is completely ousted after commencement or occupied by the Legislatures Act.
Probably
that matter, I am citing that judgment.
Understand what I wanted from you.
Well,
either you are consciously avoiding the answer. I am again saying either the doctrine of occupied field or a doctrine of excessive legislation, a doctrine of legislations by taking a different route in bringing an amendment into a subordinate legislation, assent whereof is given by the governor or by the president, and this cannot be done by through a governor. All these things I agree for their statement. Now, the question is that they have been promoted on the basis of this particular legislation. What would be the fate of those promotions? I am just putting a questions to you. What will be the fate of those promotions?
But my humble submission
Once we declare this provision to be ultra-virus.
Then you Lordship, that I have...
Sure. He wanted a law in this subject. Forget about it. What will happen? If Supreme Court has also held that you can't bring a subordinate legislation which either runs counter to the substantive act or is repugnant to the substantive act, inconsistent with the substantive act. I understand those principles you did not.
Here it is not the subordinate legislation, man. Had it been done in exercise of power under Section 38, then you could have got the footing of the
whatever that
here under the 309 provision.
What is this problem?
Man.
Is it not a subordinate legislation? Then it is what? Cannot be regarded as a delegated legislation. Then what is the character of this?
My lord, I am just, may I read, my lord, the
59 says the governor can issue any legislation or the directions being a character of a law, just to fill up the gap or there is any penalty.
But such a power is not available with the governor when it has already been enacted. But you lordship, that is the judgment, my lord. That I am coming to, my lord. May I read, my lord? One by one.
Probably again I am saying that is my, I would have misfortune, my incompetence that I am
No, my lord. I am
unable
at least
to convince you.
My lord, your lordship, allow me only 5 minutes, my lord. Your lordship only allow me 5 minutes. What is the case exactly? Then let me place.
We understood the case. What do you think? We have not understood. We understood the case. The question will be of the ultimate relief to be gotten. We may declare provision as adopted.
My lord.
Happy?
Then consequences to follow. Consequences to follow. Then in case a provision is declared ultra virus, what would be the consequence? That has been laid down by the Honorable Appeals Court.
You will be happy with that? No further consequential orders will be passed? Then, if you are happy, we have no issue.
But only the second prayer is a promotion for direction. We have not said nothing, my lord.
No.
Beyond that, we have not said
No.
nothing. Your lordship kindly appreciate. My prayer, your lordship will find.
No.
My first prayer is to declare ultra virus.
No.
Second prayer
That
is
is why-
to consider all qualified acts.
Now you are coming in.
My lord, let them be considered.
Let me say.
I just
you have come in my clutches now.
My lord.
Correctly. You second.
Yes.
You wanted a promotion
Yes.
to what? Imaginary post or what? There must be a vacancy. How the vacancy will come? By demoting those promotees who do not have the qualification to come to a bidder post. Then the vacancy would come. There you will be adjusted. Can we do it?
My lord, if it will not be done, my lord, then that will go against the principles of
That's what I'm asking you, sir.
That is why I am saying, my lord.
Please tell me
Your lordship
to do.
Yes, my lord. I
Now I understood.
Your lordship kindly appreciate. But the judgment bundle that I have given, that at page, that is 232.
Enacted a guideline or enacted a rule or mandate that every teacher must qualify the key. Now the question, there are a lot of questions that arose everywhere in every state. Yes. First question arose whether these guidelines or the instructions has any statutory tracking or mandate which has been given is to be followed. Then the Supreme Court in one of the judgment came, no, this is mandatory.
Yeah.
And you have to follow, you can't defy. Because in one of the judgments, Supreme Court considered the genesis of the creature of this entity, how it has come, all these things were considered and then saves the mandatory. Then the RT Act came. Now the difficulty is that once they give a mandate, certain states were not following because the candidates were not having those qualifications. And there could remain a vacancy for a longer time. That was the whole difficulty with many of the state players. So they recruited those by amending something. Then it was challenged again. Then it says that you can't do it. Then large number of people who are already there. Because if they are removed, the difficulty is ultimate sufferance would be caused
to the beneficial students.
Children's.
That's why the Supreme Court in that case, if it is 5 years or less period which is left, don't insist. Let him continue and honorably go out
Without promotion. Yes.
more concerned with the promotion. I understood, sir. Let him continue and then go out. The second says that whoever has not got, then in that event 2 years period is given. You must have it.
Yes.
If you do not qualify this test, then the consequence is also provided what to do. Correct. Now the situation has started. Once the Supreme Court has given 2 years buffer to qualify, then it does not indicate at what course. Whoever the teacher having no TET qualification shall remain stagnant there, as I perceive the judge.
Yes.
Would remain stagnant there for 2 years. Let them qualify. If they qualify, there is no difficulty.
Further service progression would be dependent on acquisition of
No, that is there.
Two years.
But anybody got promotions prior to 2019 without qualification, or them it may be applied. But after 2009 exemption provision, by taking advantage of exemption provision, they got in. But that's a question is required to be decided. But a large number of persons have got promotion. Then we have
Supreme Court has not said anything. The Supreme Court has also taken into consideration the subsequent
That will be covered by the
position. Everywhere it is there as on the date of the judgment. The Supreme Court has taken into account. It did not make any distinction between an appointment, prior appointment, after. Otherwise, the Supreme Court would have declared those appointments to be absolutely invalid, illegal, and should have thrown them out.
No, but
The position is that the 2 years have not passed. I think this judgment is valid in
hardly few months.
2020 or 2024.
2020. But it is a rider. You also kindly appreciate. Law is they cannot be considered for promotion. They cannot be given promotion. That doesn't mean without qualification one has got promotion. They will continue.
Now they have an opportunity to go for 2027.
Up to 2027 is the balance.
Well, my humble submission is
This current
the first principle what held by the Supreme Court, basing upon that RCFC Act, read with the NCT notification, that is, no promotion can be emerging without TET qualification. They have no right to be considered for promotion without TET. If at all, they will be allowed to continue those who have got promotion after 2019, basing upon this provision. Then ultimately what will happen, Malab? It will indirectly frustrate the first mandate, Malab. The first principle will be frustrated there. My humble submission before Lordship. Because had it been a case, we are not at that time in Lord Mallards more than 70,000 teachers having the qualification. But they got the promotions by marching over the qualified hands. That is the crux, Mallard. That's why they have come forward to challenge this, questioning the validity of this provision, exemption proof. Otherwise, my lord, we will get no justice, my lord. If we are, our fate has been sealed, my lord.
Sir, paragraph 214, read 15, read what it is not Article 142. Article 142 is paragraph 216. 14 and 15 is not Article 142. It is Article 141.
It is Article 141.
It is only paragraph 216 which is Article 142.
Malad. Invoked the article and extended the relaxation period.
Sir, the court was conscious that we will not terminate the service.
True, Malad. I bowed out, Malad. I don't, Malad, say so, Malad. Your Lordship, ultimately what will happen? The first principle which was upheld, Malad, that will be frustrated indirectly.
No, sir.
And we will be debarred, Malad.
You are not debarred, sir. You do not want. Now I have lost the knack of arguing as a lawyer after such a.
Malad, Your Lordship, kindly appreciate. Well, one thing, Your Lordship, visualize. On the pretext of the Orissa Elementary Education cadre rule, Malad. Malad, cadre rule in reverse, five cadres earlier, it was made 6 under this amendment. But in the 6th cadre, from the bottom stage 2, they have already crossed not 1, 2, 3, 4. They have occupied almost all the promotional posts. But particularly when we are in thousands, more than in number, we are available in the cadre. Your Lordship kindly appreciate. And basing upon the had the anybody got promotions prior to that law, my lord, then certainly for them, my lord, they may be protected. We are not saying so.
Prior to this judgment, there was nothing, because once you have entered into a cadre, and if the cadre is not differentiated on the score of TET qualified teacher and non-TET qualified teacher, it is a one single cadre. Then whoever there in a higher position of the cadre is entitled to a promotion or not promotion, to be considered for promotion. That is the vested right. The right to be considered for promotion is a constitutional and vested right.
But this is fundamental right.
Right to promotion is not.
No, yes, ma'am.
Not.
It is not the fundamental right.
Definitely not.
Ma'am, here what has happened? Chances of consideration of promotion has been taken away.
Sir, now you are emboldened because of the judgment of the Supreme Court.
No, Your Lordship, excluding the judgment, my lord, we have argued this case and concluded, my lord.
Supreme Court in paragraph 215 and 60 did not make a differentiation on a promotion by basis or on non-promotion basis. It says that in-service teacher means though the teachers who are in service now, having no TET qualification, says that if we remove them or if we dismiss their service, it will be too hard for them on that. Then he says, I am exercising my Article 140 and giving them 2 years time to complete. What? It was not to be disturbed in service till
Completion of
31st August 2027.
My humble submission with Your Lordship is, here is a case, my lord, something different.
No.
But Your Lordship, may kindly, my lord, look to this matter. What judgment I have opened, Your Lordship.